Hello, everyone. Good morning, and maybe it might be afternoon to some of you, or even evening. So today, I'd like to talk about the topic on international human rights, which is the topic for week 10 in our unit on public international and human rights law, LAWS12070, and this is Dr. Manjo Oyson, your unit coordinator. There has been a lot of discussion about international human rights, especially because, especially in the part of individuals, there is a huge concern about the value of international human rights, especially because there might be some states which, for one, do not really have any legislation or even any constitutional provisions pertaining to human rights. So if you look at the case of Australia, for example, Australia does not have under the Australian Commonwealth Constitution, there is no Bill of Rights, such as what you see in the United States or perhaps in some of the constitutions, such as the Philippines. And there is no single law in Australia that codifies the human rights of individuals. And instead, what we do have would be implied political rights, according to decisions made by the High Court of Australia. And if in an advanced country, in a country where we know that human rights are generally respected or generally enforced, such as in Australia, and in a state such as Australia, where you know there is no single domestic legislation that codifies human rights, or a Bill of Rights isn't even in the Australian Commonwealth Constitution, you can just imagine the significance of such an absence in other states, where there might not be any right to religious freedom, there might be less rights for ethnic minorities, there might be repression towards people of a different sexual orientation, such as, you cannot, in some states, you cannot be openly very demonstrative of your sexual preferences, especially if they do not follow what is expected of a particular culture. So, for example, gay and lesbian relationships would not only be frowned upon in some states, but they would actually be criminalized in some states. Same thing with freedom of religion, which are quite common in the United States or in Australia or even in New Zealand, in a lot of the democratically established states. There is no issue about right to freedom of religion. But in some states, there is no such thing. And the mere fact that somebody may be holding a Bible or in possession of a Bible, or may even be undertaking some kind of a Bible study in one's home, or perhaps maybe meeting with some friends for a prayer group session, these can lead to that person or those persons being subjected to criminal punishment, including perhaps stoning, caning, and so on. And so therefore, the discussion about human rights continue to have value today, because we can still see so many instances of human rights violations going on in various parts of the world. And we know that in many cases, human rights violations were actually done through the instrumentality of the state. And it is, in fact, the state itself which is meant to be primarily responsible for ensuring that human rights of persons are respected, and yet it is also states who are themselves the main violators of human rights. So there is an importance to having a discussion about human rights, so that, number one, we need to know when we speak of international human rights, does that rest on some particular principles of international law? Does that rest on international customary law? Or does it rest on treaties that states have entered into pertaining to international human rights? Or is the reliance relating to human rights based, perhaps, on domestic legislation? And what if there is no domestic law that pertains to human rights? So what is then the intersection and the interplay between human rights as found in international law in relation to domestic human rights? And that's one topic that will be the topic that we examine in this lecture podcast. And so after studying this topic, You should be able to discuss and explain international human rights and the international human rights regime, as well as the enforcement of international human rights and the human rights law as it applies to Australia. Now, what I'd like you to do in the meantime is really to think about these questions as we examine the topic on international human rights. And I wish to point out that this is it's an overview of international human rights law, because if you wish to have a very detailed and extended discussion and examination of the field of international human rights law, there are in fact various textbooks that focus exclusively on the topic. And there are also subjects and courses that teach international human rights as a single unit of study. So I raise that point because we're only able to cover broadly the topic on international human rights this week as well as next week in week 11. So this cannot be a broad coverage because international human rights law is only an aspect of international law in general, in the same way that when you speak of international criminal law, there are in fact exhaustive discussions about that particular topic, but because we're looking at public international law in general, we only have an opportunity to examine this very important topic in weeks 10 and 11, and therefore I would invite you, if you wish, to read textbooks on international human rights law in particular, such as that written by Professor Olivier de Schutter. So, as we look at this particular topic, these are some of the questions which I'd like you to think about. Number one, firstly, a lot of students would often say, and I encounter them, these assertions in some of the papers that have been submitted, where they say that this particular state, for example, has violated the United Nations Declaration of Human Rights, or what we call the Universal Declaration of Human Rights. So that raises the basic question: does that mean that the Universal Declaration on Human Rights is legally binding on states? Okay, so that's a question that I'd like you to ponder. Is the Universal Declaration of Human Rights legally binding on states? And as we examine this particular topic further in a short while, the other thing we need to ask is that because we know that many states, or a majority of states in the global community have in fact entered into treaties that reflect their commitment to respect and promote international human rights. So, because they've entered into treaties, these are therefore legally binding obligations on the part of the states. The question is, would the ratification by a state, for example, of a treaty or covenant on human rights mean that the treaty or human rights which are embodied in these treaties then become legally enforceable rights for the citizens of a ratifying state or of a state that is a party to a treaty or covenant? So, for example, if a state becomes a party to the International Covenant on Civil and Political Rights, would it mean that such the effect of being such a party to the treaty, having for a state to have entered into a treaty, does it mean that the citizens of a state can now claim those rights and then seek to enforce them in the domestic forum? So we're going to examine that as well. And thirdly, assuming that an individual asserts that his or her international human rights have in fact been violated or not promoted within the state, what exactly is the recourse? Is there a remedy for the individual perhaps to go to the International Court of Justice or perhaps the Human Rights Commission? And in particular as well, we should be asking whether or not an individual can seek to apply to domestic courts for the enforcement of certain rights which are embodied in treaty provisions. So, for example, if there is the freedom against discrimination on the basis perhaps of sex, or freedom against discrimination on the basis of somebody being a minority, can a citizen of a state that is a party to a particular international covenant or a treaty that embodies certain human rights pertaining to equality, pertaining to non-discrimination, can that individual then seek to enforce his or her rights under in the domestic courts of a particular forum. And if we assume that there are limitations in terms of the enforcement, perhaps, of international human rights treaties internationally, and even domestically, can it then be said that, you know, they're ineffectual, they're empty words, they're dead law? They would be dead law, they would be dead letter and have no effect whatsoever. These are the questions we would have to answer as well, if, you know, there might be problems about enforcement. So I'd like you to think about those questions. And so let's start to talk now about international human rights law. But first of all, we need to remind ourselves about basic international law principles. And one of the basic international principles of law would be state jurisdiction. And we recall that one of the components of state jurisdiction is what we call prescriptive jurisdiction, or the power of a state to pass laws or prescribe laws that mainly would cover or subject its citizens or subjects to the laws of a particular state. So ultimately, therefore, when it comes to laws, it is a state which has the authority, the sovereign authority, the plenary authority to pass laws, not only which might end up restricting certain rights of individuals, but at the same time promoting or protecting certain rights of individuals. And it is therefore not only, it therefore reflects the fact that it is a state which has the jurisdiction, the power to perhaps curtail what might be human rights, or it is within the power of a state to determine that, you know, certain rights ought not to be human rights. And when we speak, therefore, of human rights, we also need to clarify that there is a view, therefore, internationally, that there are certain human rights that adhere to an individual and that make him human. So these are known as fundamental or basic human rights. So in the absence of certain rights that are not recognized in an individual, it is in fact difficult to say that you have an individual. So if you have an individual, it cannot just be a person with a body. It has to be a person in whom certain rights inhere as a human. And a lot of these rights might be inviolable in the sense that you cannot pass a law that would violate some of these rights, which would diminish his quality or his attribute as a human being. So we've talked about state jurisdiction. The other important international principle relates to sovereignty. And we know from our discussion about the case, for example, of Greece versus Turkey, that there is a recognition in international law about the sovereignty of a state, which is a fundamental attribute of a state, so that a state is supreme within its own territory. And so therefore, no other state has the power or right to seek to diminish or even interfere with the sovereignty of a state. And certainly not courts, and certainly not the United Nations, because again, a fundamental attribute of a state, as recognized in the UN Charter and in international law, is the equality of a state. So therefore, for a state to say to another state that, you know, you are not promoting or not respecting enough the human rights of individuals, that can be an attempt to erode or even diminish the sovereignty of a state. So at the end of the day, as far as international law is concerned, there is huge recognition of the sovereignty of a state, that it has full, supreme, and plenary powers within its own territory, and there is no other state, no international body that would have the authority to impair that state sovereignty. So that again is a general principle. And a third general principle that we need to remember is that in the case of France versus Turkey, we know that international law is created on the basis of the consent of states. It's based on state consent. So if a state, therefore, does not recognize a particular so-called international law, then it means that it cannot be bound by that particular international law. Save in the case of general customary international law, and especially those which might be based on what are called to be erga omnes obligations, and obligations that the world community would generally recognize. But as a key point, because of the principle of sovereign equality and the principle of state sovereignty, as well as the recognition in the case of France versus Turkey, that international law is mainly based on state consent. You cannot assume that a state would have international law obligations pertaining to international human rights without its consent. And so this means, therefore, that in general, as far as domestic human rights are concerned, as far as international human rights are concerned, these are matters that are solely for a state to determine on its own. So that's a crucial point we should be discussing. So having made those clarifications about basic international principles that can have an impact on international human rights law, we need to be able to trace the development of international human rights. Again, we need to remind ourselves that as far as international law is concerned, in international law, it is actually states that are the main subjects of international law. And it also means, therefore, that individuals are not subjects of international law. So as far as international law is concerned, the subjects of international law, the ones with rights, duties, and obligations are the states, and it is not individuals. So therefore, an individual cannot say that he or she has a standing or certain rights under international law, because the basic subjects of international law are states. And as I already mentioned, in the case of Germany versus Italy, customary international law recognizes state sovereignty. So historically, therefore, when you look at the evolution of what have come to be known today as international human rights, they have started really from within states that recognize that individuals have certain fundamental, basic, and inalienable and inviolable human rights. And as we see shortly, we will see this in the case of the Magna Carta in the UK in the 12th century, as well as the Bill of Rights in the United States Constitution in the 17th century, which we will examine. So historically, it has always been states which have sought to promote and respect human rights. And this also means, therefore, that because it was states that originally themselves were the ones who were responsible for promoting or protecting human rights, then you can have differences across states in the way that they would promote or even respect human rights. There might be some states which, are pretty liberal towards human rights, such as the United States and the UK, but other states, as we know, especially those whom we may consider to be repressive regimes, or even, totalitarian states or states that ensure that there might just be a single a religion that ought to be promoted, which is such as Saudi Arabia. We know that human rights, therefore, can really be a matter of a state, and there are huge variations and disparities across states in the way that they promote and respect human rights. So some states promote human rights, some states repress human rights, some states violate human rights. And not only do we see this in Saudi Arabia, for example, where there is still the problem about women being unable to drive because they, and you wonder, isn't that discrimination? Doesn't that violate certain human rights about equality of sexes? In Afghanistan and some parts perhaps of Pakistan, we know that there is still a lot of intolerance towards women being involved in certain sectors of industry or society. So they cannot be involved in certain trades because they are women. And in that particular case, there are a lot of states which look down upon women. If you hear about India, for example, there's that culture which talks about the dowry that women or brides have to pay to their husbands in order to get married, and then that raises the question about equality of sexes, which is in fact embodied clearly in the U.S. Constitution, recognized in the UK Magna Carta, and recognized now in international treaties. And yet, so there is that disparity. If you look at the case, for example, of China, you know, you talk about freedom of political communication, a right recognized by the High Court of Australia in Australia, but in countries such as Russia and perhaps countries such as China, if you come up with communications that might seek to perhaps question the legitimacy of the Chinese government, you could go to jail. Same thing with Thailand. And in the Philippines, for example, there are two disturbing trends now, because number one, because of President Duterte's desire to continue with his the war against drugs. As of today, there are more than 20,000 individuals who have been suspected of using drugs, so they're just drug users. But because of the suspicion that they may have been using drugs, then they have been summarily killed by the police and vigilante groups. So the mere fact that a person is suspected of drugs can mean that that person will get a bullet in his head without ever having a chance to be arrested by the police, without ever having been given the chance to be tried before a court to determine whether or not he's in fact guilty. And yet, so it's pretty fun in the Philippines, because although there is a law there which prohibits the imposition of the death penalty by the courts, the death penalty is in fact commonly imposed by the police and by vigilantes there against persons who they perceive to have used drugs. So so the Philippines is not a place for people who casually think that they could just use drugs, whatever that might be, because they could get killed there. The second problem now, again, is a question about the rights of children, because we do have a covenant concerning children. But in the Philippines, there is an attempt to try to lower the age of criminal liability to even children who are the age of 10, rather 9. So there is a huge chance the law will be passed in a short while in the Philippines, where children as young as 9 can now be the subject of criminal liability. So it's a very disturbing development, and again, that shows just how much has changed, and yet how much has how little has changed in relation to international human rights across the world. So the international human rights mainly began from the human rights being recognized by states, because as far as the development of the world community and the development of international law, this is a new phenomenon that happened mainly in the 1900s after World War I and after the Second World War. Of course, you can look at the Geneva Conventions in the 1800s as well. But essentially, international human rights is a new evolution, which happened mainly in the 1940s, if you do not count the Geneva Convention, let's say on the treatment of civilians during armed conflict. But human rights, international human rights, as distinct from human rights which might be embodied in international humanitarian law pertaining, for example, to the treatment of civilians during armed conflicts, we can say that they were mainly promoted by the United States Constitution Bill of Rights in 1791. So the United States Constitution has a Bill of Rights. For example, in Amendment 1, it provides that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. Under Amendment 4 of the U.S. Constitution Bill of Rights, it says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and the warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. In Amendment 6, in all prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime shall have been committed. So the United States Constitution Bill of Rights has been a very important legal document that then influenced the development of human rights internationally as well as domestically. So you will see a lot of state constitutions, such as the Constitution of the Philippines, which actually embody the Bill of Rights of the US Constitution. And there are many other constitutions of other states that do have a Bill of Rights. Again, embodying the same Bill of Rights recognized under the US Constitution. But again, there are also parts of the world, such as Saudi Arabia and Iran, where you do not have a freedom of religion in the sense that you're free to practice your religion, perhaps of Christianity. If you do, you could go to jail, or you could be arrested. Certainly, you cannot speak of equality of individuals, because in these countries, in these strongly male-dominated societies, women do not have equal rights. So there is that issue. Now, but even though it has been the United States, through the United States Constitution, that has been a very visible landmark in terms of the development of international human rights, there is international human rights actually has a more ancient origin, especially in the UK, through the Magna Carta. Because in the UK Magna Carta, the Great Charter of 1215, which was issued by King John of England to address the political crisis that he faced in 1215, the Magna Carta established the right of all free men to justice and fair trial. And so that the third clause of the Magna Carta stated, no free man shall be seized or imprisoned or stripped of his rights or possessions, or outlawed or exiled, or deprived of his standing in any other way, nor will we proceed with force against him, or send others to do so, except by the lawful judgment of his equals, or by the law of the land. To no one will we sell, to no one deny or delay right or justice. And so we would be very familiar with the UK Magna Carta, given the historical link between Australia and the UK, because as we know, the Australia or the Australian states essentially started off as colonies of the UK. And so there is some strong familiarity with the UK Magna Carta historically. And certainly the French, contemporaneously with the United States, also passed the French Declaration on the Rights of Man and of the Citizen in 1789. And of course, this was closely related to the bloody French Revolution, which saw hundreds of thousands of individuals brought to the guillotine during the French Revolution, which included Maria Antoinette. And so therefore, you have the development of international human rights starting off from states, so that when we speak of international human rights law, as we see later on, international human rights law is actually a combination of treaty law entered into by states, but become parties to international treaties pertaining to international human rights. But at the same time, it also consists of domestic human rights laws. So when we speak of international human rights, we know that international human rights is a combination of treaty obligations as well as laws of a particular state pertaining to human rights. In some states, such as the United States, there being a party, for example, to the International Covenant on Civil and Political Rights does not really add anything extra to citizens of the United States, mainly because they have already the United States Constitution, Bill of Rights. Same thing with the Philippines. So it doesn't add anything because the content of the substantive rights of individuals recognized, for example, in the International Covenant on Civil and Political Rights are already there in the US, in their constitutions. In some states, though, such as Australia and New Zealand and the UK, where there is no written constitution, there's an added value in a state being a party to these international human rights treaties, because there is no written constitution to speak of. So for some states, some states where they do not have a Bill of Rights that embody certain fundamental human rights of individuals, there is a need, therefore, to kind of become a party to an international treaty promoting and respecting international human rights, which which then have an opportunity to influence legislation as well as the common law in specific states, such as Australia, because as we said, in Australia, there is no Bill of Human Rights in the Australian Commonwealth Constitution, and instead, what we do have are human rights that are recognized on the basis of the common law, particularly on the basis of the recognition by the High Court of Australia, for example, that there are certain implied political and human rights under the Australian Commonwealth Constitution, but these are implied political and civil and political human rights under the Australian Commonwealth Constitution, because Australia is a democracy. Okay, so, but it is not a set of express rights that you normally see in the constitutions, for example, of the US and the Constitution of the Philippines. So, when we examine, therefore, the evolution of international human rights today, it is actually an attempt on the part of the world community to promote international human rights, because they know that, you know, states, although they're meant to promote human rights, are oftentimes the main violator of fundamental basic human rights. In other words, on the part of some states, they do not recognize certain fundamental human rights. To them, you know, they do not even exist. And so a state, because of the power, you know, the right to sovereignty, the right to sovereign equality, and the attribute of jurisdiction, it is up to a state to do what it likes within its territory. So those mean that, you know, those are gargantuan powers on the part of the state. They might be called Leviathan, in the sense that, you know, a state can do practically anything it wants within its own territory. And so therefore, when you look back, for example, especially to World War II, during World War II, for example, there was the genocide of Jews by the Nazis, and there were war crimes committed by Japan during World War II as well. We see that, you know, especially during World War II, there was hardly a recognition of human rights on the part of individuals. So to the Nazis then, if you are a Jew, you're not even a human being, and you are just a number, maybe not even a number. And so therefore there were millions, at least 6 million Jews who were, you know, killed in the gas factories of Nazi Germany, or killed by firing squad. During World War II, the Japanese Imperial Army brutalized and killed and murdered hundreds and thousands of innocent civilians, especially women. And it was quite common during World War II for Japanese soldiers to use women as comfort women. So they forced women during World War II to become, well, it's difficult to call them prostitutes, but as comfort women, who were then used by Japanese imperial soldiers, you know, for sex against the will of a woman. So especially during World War II, therefore, or prior to World War II, because there was no World War II initially, you know, it was just Hitler and Japan rampaging across states and territories, trying to dominate the entire world. You know, there was not only a lack of respect for basic human rights, but even, you know, an antipathy, an absolute denial of basic human rights of individuals. A lot of individuals were not treated as humans, and they were not seen as people who had rights on their own because they are humans. And again, you know, even as we talk about this, keep in mind that this is a problem that persists even today. So, as a result of World War II, there was the increasing recognition. There was an increasing recognition that there ought to be fundamental human rights that should be recognized by all states. And we see this in the United Nations Charter, as well as the Universal Declaration of Human Rights, which we examine shortly. So for example, when you look at the UN Charter, and remember that the UN Charter came about as a way of developing or creating the United Nations organization, which was after World War II. The preamble of the United Nations Charter provides that we, the peoples of the United Nations, determined to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind, and to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women and of nations large and general. In Article 55C, the UN Charter also provides that there must be universal respect for and observance of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion. So we see this in the UN Charter. We see that as well in the 1948 Universal Declaration of Human Rights. So for example, in the 1948 Universal Declaration of Human Rights, among the rights enumerated in 30 articles are, under Article 1, all human beings are born free and equal in dignity and rights. In Article 2, everyone is entitled to all the rights and freedoms set forth in this declaration, without distinction of any kind, such as race, color, sex, language, religion, and so on. In Article 3, everyone has the right to life, liberty, and security of person. In Article 5, no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. So, given the fact that we have the UN Charter, which recognizes fundamental freedoms for all without distinction as to race, sex, language, or religion, and we also have the 1948 Declaration of Human Rights, which, among others, not only talks about equality of sexes, equality of races, and prohibits discrimination on the ground of sex. And we also see in the Universal Declaration of Human Rights the fundamental right to life, liberty, and security of person, that no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. The question that arises is that if these are human rights recognized in the UN Charter and recognized as well as the 1948 Universal Declaration of Human Rights, how is it that today there are still so many states which continue to violate what appear to be human rights as recognized in international law? And even the United States, you should know, was really important in influencing the development of human rights in other states through its Bill of Rights. We know that even the United States is not really free from allegations that it may be violating human rights, even found in the US Constitution. So, for example, we know that in the United States, there continues to be some so-called, racial profiling, so that people who are, do we call them black? Or people who might belong to the minorities, the Afro-American, the Afro-Americans are more often than not subject to police brutality. And we know as well that there is the rise of white supremacy in the United States as well as other parts of the world, which liberally try to promote the idea that it is whites who are supreme, and that if a person is not a white, meaning he is black or he is brown or of a different color, that person is of a lesser race. So how is it that this is happening in the United States? And we know as well that as a result of the Abu Ghraib scandal, or even the allegations of torture in Guantanamo, it would appear that even the United States has been responsible for the use of torture against suspected international terrorists belonging to Al Qaeda or maybe ISIS. So what's happening then? If the United States, for example, is in fact a member of the United Nations, because it is, and the United States is a signatory to the Universal Declaration of Human Rights, and of course is a party to the United Nations Charter, which is a treaty and an international binding legal document. So why is it that states continue to violate human rights today, including the United States? So that's something that we need to try to think about. Now, apart from the UN Charter, which is, as I said, a treaty, a legally binding international instrument under international law, And we also have the Universal Declaration of Human Rights of 1948. Apart from that, there are other international instruments that seek to promote and recognize international human rights. These include the 1966 International Covenant on Civil and Political Rights, the 1966 International Covenant on Economic, Social, and Cultural Rights. You also have the 1966 International Convention on the Elimination of Racial Discrimination. You also have the 1979 Convention on the elimination of all forms of discrimination against women, the 1984 Convention against torture and other cruel, inhuman, and degrading treatment, the 1989 Convention on the Rights of the Child, and the 2006 Convention on the Rights of Persons with Disabilities. So because apart from the 1948 Universal Declaration of Human Rights, all the others are actually treaties. So these are legally binding documents that bind states. And so that therefore, if a state violates the provisions of any of these conventions, that state is in breach of international law. Okay? Now, but let's just quickly go through the Universal Declaration of Human Rights, and then we'll go back to the treaties. The main problem we have with the 1948 Universal Declaration of Human Rights, number one, is that one, it is not a treaty. It is not a treaty. It is just a declaration. There was never an intention on the part of any state that the Universal Declaration was meant to create legal obligations. So in other words, it is difficult to say that a state is in violation of the Universal Declaration of Human Rights, because the Universal Declaration of Human Rights does not embody any binding legal obligation on the part of the state, because it is merely a declaration. It is not a treaty, as would be recognized in the Vienna Convention on Treaties, because it was never intended to create legal obligations on the part of states. So you have to be careful as future lawyers and as law students say that a state has violated the Universal Declaration of Human Rights, because it is not a source of rights in international law, because it is not legally binding on states. So it would be legally incorrect to claim that a state has breached its duties or obligations under the Universal Declaration of Human Rights. So in other words, the Universal Declaration of Human Rights is what might be called soft law, because although it might talk about rules and regulations, recognition of certain fundamental human rights and freedoms, these human rights really are not enforceable against signatories. And you don't really talk of parties, because when you speak of parties in international law, you're looking at states that seek to be bound legally by an instrument. And so you only have signatories, but even the signatories of the Universal Declaration of Human Rights, even if a state is a signatory, you cannot enforce any of the so-called, any of the rights embodied in the Universal Declaration of Human Rights, because they are not legally enforceable. But the question then is, assuming that the Universal Declaration of Human Rights is not a source of legal obligation, it is not a source of law, and a state that does not respect the human rights recognized in the Universal Declaration of Human Rights cannot be in breach of its obligations under international law. Does it mean then that the Universal Declaration of Human Rights is ineffectual in promoting human rights? It really has no effect. Is that the implication? The answer is no, because although it might be soft law, we need to remember that states are essentially, although state is a legal fiction, it actually operates through human beings. And so states, like human beings, they don't just act on the basis of legal obligations, just like us. So when we speak of ensuring that we are nice to other persons who are nice to us, there is no law that we need to be nice to other persons, but we seek to be nice to other persons. We seek to be nice to our neighbors. We seek to be fair. That is not a legal obligation, but that is something that we seek to do, because as human beings and as individuals, we do look at what are considered to be moral and ethical considerations. So we don't just blast our horns when we don't like somebody on the road. It's not courteous to do that. We don't say bad things against an individual in general, because it would be lacking in grace for us to do that. And certainly we don't try to cut into a queue. So if there's a queue or a line that is formed, we try to observe that we need to follow the queue. But it's not because of a legal obligation, it's just a moral obligation. And so therefore we know that just like individuals in international law, states also are aware that it's not all about the law, it's also about trying to appear to be a state that does recognize certain democratic values, certain ideals, certain human rights. So there is an effect, not legally, but it does influence the activities of states. But so in other words, states do act not just on the basis of moral considerations. They also wish to promote goodwill. They want to promote the reputation. They want to promote community and friendship with other states, and you can only do that by being identified as a state that recognizes human rights. Otherwise, you're going to be a state that other states would not wish to make friends with, because you can be considered to be a repressive regime, for example. So international reputation matters as well in international law. But more importantly, the 1948 Universal Declaration of Human Rights did lead to certain treaties, very important treaties, such as the 1966 International Covenant on Civil and Political Rights, or the ICCPR, and the 1966 International Covenant on Economic, Social, and Cultural Rights, or the ICESCR, and these are legally binding on the states parties to them. So when we speak of certain fundamental human rights, the basis for an assertion that there are human rights that are legally binding on states should not be on the basis of the 1948 Universal Declaration of Human Rights, but on certain treaties signed or entered into by states, such as the ICCPR or the ICESCR. Okay, because the Universal Declaration of Human Rights of itself is not a source of legal obligations. So we know, therefore, that as far as the international instruments on international human rights are concerned, we have the UN Charter, which talks about equality of individuals. We also have the Universal Declaration of Human Rights and the other treaties. So the Universal Declaration of Human Rights is not a source of legal obligations. The UN Charter, we know, is a treaty, and therefore it is a source of legal obligations. But any rights which might be found in the UN Treaty, recognizing, for example, the universal respect for and observance of human rights and fundamental freedoms under Article 55C of the UN Charter, so that all without distinction as race, sex, language, or religion. That still, although there is a recognition of human rights, it doesn't mean that they necessarily translate into legally enforceable rights on the part of states. And you would need a treaty for that through the ICCPR, for example, so that these rights which are recognized in the UN Charter can then be enforced. But even having talked about the issue of a recognition of international human rights under international law, and the talk about whether these rights now become rights in the sense that they are a source of obligation on the part of the states, the other question that we ask always is about their enforceability. That is a totally different matter altogether, as we see in a short while. So again, as a reminder, because this is an overview about international human rights law, we really don't have the opportunity to examine in detail every single treaty that pertains to international human rights. It will have to be up to you to try to examine them in more detail. What is important, however, is that we are able to look at the key principles that impact on international human rights law from the viewpoint of international law, particularly pertaining to jurisdiction, sovereignty, and, for example, questions about enforcement of legal obligations. So let's look at the International Covenant on Civil and Political Rights. This was entered into force in it was, state parties. States started to become signatories to the ICCPR in 1966, but it only went into force about 10 years later on 23 March 1976, upon its ratification by at least 35 states in accordance with Article 49. As of April 2014, there are 168 parties to the ICCPR. But because there are probably about 200 states today, it means that there are some states which are not parties to the International Covenant on Civil and Political Rights. So, as you know, as we can clearly see, while a majority of states are parties to the ICCPR, not all are. So, when you look at states such as China, Cuba, Nauru, and Palau, they are not parties to the ICCPR, and they're not even signatories. They haven't even signed the International Covenant on Civil and Political Rights. So these states are not even signatories nor parties to the ICCPR. Although there are 168 parties to the ICCPR, we also know that there are some states. When I talk about China, Cuba, Nauru, and Palau, these are signatories to the ICCPR, but they are not parties to the ICCPR, so they are not bound, legally bound. They've simply signed it. They were saying that the obligations under the ICCPR become binding only by ratification of their respective government organs, usually the parliament, ratifying that the treaty becomes part of the law of the land. So some states are signatories, such as China, Cuba, Nauru, and Palau, but they are not parties to the ICCPR. So therefore, the ICCPR is not a source of any legal obligation in these states. There are, however, also 22 other parties, two other states that are not parties, not even signatories to the ICCPR. These include Brunei, Malaysia, Singapore, Oman, Qatar, Saudi Arabia, United Emirates City, and even the Vatican City. These states are not signatories nor parties to the ICCPR. So when you look at the ICCPR, it identifies certain fundamental individual human rights and freedoms. So as a treaty, it is legally binding instrument. It is a legally binding instrument that creates obligations for the state parties. So that is those that have ratified or acceded to it. So ratified means that these were the original signatories to the ICCPR in 1966. And there were others, however, that after even after it came into force, they then acceded to it. So in other words, maybe at about 2000, there was a new state that was created. That state then said, we will accede to the ICCPR and therefore recognize that we are legally bound under the covenant. Let's talk further about the ICCPR, because there are problematic limitations about the ICCPR. Because whilst we will say, there are certain fundamental human rights that are recognized in the ICCPR, therefore, I can enforce it. And when you say that, an individual can try to enforce rights recognized in the ICCPR, where is enforcement going to happen? Is it going to happen because an individual can file a complaint with the International Court of Justice, with the United Nations Commission on Human Rights? Can it be enforced in domestic courts? So the issue of enforcement is a different issue altogether. But before we go there, let's just examine some of the rights recognized by the International Covenant on Civil and Political Rights. In Article 2.1, it states that each party to the present covenant undertakes to respect and to ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. The rights which the ICCPR protects also include the right to life, freedom from torture, right not to be enslaved, right to liberty and security of person, and right of freedom of thought, conscience, and religion, as well as equality before the law. So there are numerous rights, about 30 of them recognized in the ICCPR. The problem, however, as I already mentioned, is that not all states are actually parties to the ICCPR. So China, Cuba, Nauru, and Palau are not parties. There are some 22 states which are neither signatories nor parties to the ICCPR, including Brunei, Malaysia, Myanmar, Oman, Qatar, and Singapore, and Saudi Arabia. The bigger problem, however, is that under the International Covenant on Civil and Political Rights, and we're looking now at enforcement, let's assume that there is an individual, a citizen of a state, that feels that a state that is a party to the ICCPR, to which he belongs. So you might be an Australian citizen, and the Australian citizen feels that Australia as a state is in violation of the ICCPR. And we know that, Australia is a party to the ICCPR. The question then is, does that individual or citizen have recourse to international tribunals? So the Human Rights Committee, for example, was created under the ICCPR with a duty of ensuring that the rights in the ICCPR are in fact respected and promoted. However, under the ICCPR, only a state can file a complaint to the Human Rights Committee. So that if you are an individual, if you're a citizen of a state that is in breach of its obligations under the International Covenant on Civil and Political Rights, you cannot complain to the Human Rights Committee, because only states can complain against another state with the Human Rights Committee about violations of the International Covenant on Civil and Political Relations. The problem, however, is that the idea about right to life, which can talk about right to life as in do not have the death penalty. How about right to life in terms of the right to abortion? How about right to life in terms of ensuring that everyone has access to proper medication and to a health system? What I have pointed out is that certain rights are actually quite difficult to pin down. They're too broad. And it's so difficult to say what exactly is a right to life, except to say that no person should be arbitrarily deprived of life. But to say that everyone has a right to life, you might ask what kind of life? And does it mean, as I said, the right to education and so on? And we speak of freedom from torture, but what is torture? That is left for states to define. And there is no customary international law yet against torture. Instead, what you have is a UN Convention against torture, meaning it is based on state consent, meaning entry, being a state being a party to a treaty. So therefore, one of the bigger problems about the international human rights is the problem of what it actually comprises of. And different states have different views of what is a human right. And so therefore, states in general have really little interest in trying to police human rights violations by one state. And very few would complain to the Human Rights Committee. And one note we should remember is that in 1991, at that time, Australia was already a party to the International Covenant on Civil and Political Rights. But we had an individual, an Australian citizen, Nicholas Tooney, who filed a complaint, and we're going to look at this again in a short while, who filed a complaint to the Human Rights Committee that Australia was in breach of its legal obligations under the ICCPR because Tasmania, which is of course a constituent state of Australia, had an anti-gay law, an anti-sodomy law. Therefore, during that time, in the 80s and 1990s, for example, Tasmania had a law which criminalized homosexual sexual behavior of gay men. And so therefore, Nicholas Tooney at the time filed a complaint to the Human Rights Committee. And so although Australia was a party to the ICCPR, the Human Rights Committee did not take cognizance of the complaint because under the ICCPR, only states can file complaints for violation of the ICCPR. Now, the other point is that under the ICCPR, a state may have recourse against another state under Article 421(1)(a) of the ICCPR only after all available domestic remedies have been invoked and exhausted in the matter in conformity with general recognized principles of international law, including, the principle of international law pertaining to sovereignty and jurisdiction. And so that's a problem there. There has to be an exhaustion of domestic remedies before one state can even file a complaint with the Human Rights Committee. But even if a state were to file a complaint against another state for violation of the ICCPR under Article 41(1)(a) of the ICCPR, the power of the Human Rights Committee is in fact weak because the Human Rights Committee cannot make any legally binding decision. It can only make a report which a state is free to accept or not, meaning it's up to the state to determine whether it needs to take corrective measures. So the Human Rights Committee cannot make any legally binding decision, unlike the International Court of Justice. So that's the problem there. And because of, and under the ICCPR, any violation of the ICCPR cannot be brought before the International Court of Justice. It can only be done through a complaint with the Human Rights Committee. And of course, an individual certainly does not have a right under international law to file a complaint against one state with the International Court of Justice, because only states are mainly the subjects who have the right to file complaints with the International Court of Justice. Now, the other point we need to remember, which I'd like to emphasize, is that although there is a problem about enforcement of the International Covenant on Civil and Political Rights, because individuals cannot file a complaint with the Human Rights Committee under that particular covenant, we do know that states do not act on the basis solely of what are legally binding obligations, but also with a desire to act in goodwill, with comity, and try to protect and promote the reputation in international law. So these do have an influence. So whilst it may be difficult to file a complaint, for one state to file a complaint against another state on the basis of a violation of the ICCPR, there is still the world community which can provide worldwide condemnation against the conduct of states which might be in breach of the ICCPR. And of course, that doesn't always happen, because we know that you can have Saudi Arabia, you can have the Philippines, which today do not really properly recognize certain rights under the ICCPR. In the Philippines, for example, in its constitution, there is a right to life, to liberty and property under the Philippine constitution. Freedom from arbitrary arrest and detention is also recognized in the Bill of Rights in the Philippine constitution. But as I mentioned already, today there are more than 20,000 individuals who have been killed by the Philippine police or vigilantes, who are part of the police force actually, who have murdered more than 20,000 individuals because of a suspicion that these individuals used drugs, not really dealing drugs, just the suspicion of using drugs. So a mere accusation on the basis of what a neighbor says, a mere accusation because somebody's angry at you, can get you killed in the Philippines. And that's a violation, obviously, of the ICCPR and a violation of the Philippine Constitution itself. But there is a problem of enforcement. Who's going to go after the police? Who will go after the Philippine president himself, who is the #1 murderer in the Philippines? So that's the problem there in international law. Now, however, many of the state parties to the International Covenant on Civil and Political Rights entered into another treaty. This is known as the first optional protocol to the International Covenant on Civil and Political Rights. So it is itself a treaty. The first optional protocol is itself a treaty, but it is separate from the ICCPR, although very much related to it. It opened for signature on 16 December 1966 and entered into force on March 23, 1976. Today, it has about 115 parties, 115 compared to the 168 parties of the ICCPR. So in other words, over 50 states have not agreed to be bound under the first optional protocol. But a key point under the first optional protocol to the International Covenant on Civil and Political Rights is that individuals now can file a complaint with the Human Rights Committee if the state to which they belong is a party to the International Covenant on Civil and Political Rights, and also a party to the first optional protocol to the International Covenant on Civil and Political Rights. So under Article 2 of the protocol, it provides that subject to the provisions of Article 1, individuals who claim that any of their rights enumerated in this covenant have been violated and who have exhausted all available domestic remedies may submit a written communication to the committee for consideration. And under Article 1 of the protocol, it provides that if the state party to the covenant that becomes a party to the present protocol recognizes the competence of the committee to receive and consider communications from individuals subject to its jurisdiction. So in terms of the right of an individual, of a citizen, to try to enforce rights under the International Covenant on Civil and Political Rights, it has to be based on the first optional protocol to the International Covenant on Civil and Political Rights, because under the ICCPR itself, as we said, it is only states that can file a complaint against another state for violation of the ICCPR. If a citizen, an individual, seeks to assert that a state that is a member of the ICCPR has violated that particular treaty, that individual must seek recourse under the first optional protocol to the International Covenant on Civil and Political Rights. It means, therefore, that only state parties to the first optional protocol to the International Covenant on Civil and Political Rights have given their citizens the right to file a complaint with the Human Rights Committee. But as noted, although there are about 168 parties to the ICCPR, there are only 115 state parties to the first optional protocol. So there are more than 50 states still that have not given their citizens any right to file a complaint to the Human Rights Committee. Okay, so if you look at the first optional protocol to the International Covenant on Civil and Political Rights, one of the key limitations you see is that before an individual can submit a written communication to the Human Rights Committee, that individual must first have exhausted all available domestic remedies. So without the exhaustion of all the available domestic remedies, that individual cannot submit a written communication to the HRC. The other problem is that in general, the HRC is generally toothless in relation to such communications. It's really powerless because even once the HRC has arrived at the determination of the matter, its power is only limited to forwarding its views to the state party concerned and to the individual. It's just in the form of a report. It makes no binding decision. There is even no decision. It's just a report. It just forwards its views. So in other words, if you have a state that doesn't really care much about what the international community thinks about itself, then nothing's going to happen, because there is you cannot say that a state has breached its obligation to obey a decision of the HRC, because the HRC does not render any legally binding decision. Now, so even in those few instances where the HRC has forwarded its views in the form of a general comment, they've generally been somewhat docile, and this may not augur well for actively promoting this kind of work. So in other words, the HRC has generally been very polite. The HRC has generally tried to rankle states that have been accused of violating the ICCPR, or the first optional protocol to the International Covenant on Civil and Political Rights. Now, even though we have made clear that the Human Rights Committee is generally powerless because it doesn't render any legally binding decision, it doesn't mean that the HRC is unable to influence state actions, because as we see in the case shortly of the case of Tunen versus Australia, Australia did end up changing its laws concerning sodomy. I mean, the laws of Tasmania in relation to sodomy, on the basis of the HRC report, which said that Australia was in breach of its obligations under international law for discriminating against men in relation to sodomy and homosexual sexual behavior. So let's have a look again at the situation in Australia pertaining to human rights. So again, let's clarify, when you speak of international human rights, there are two dimensions to it. One would be human rights embodied in domestic law, meaning in the laws of a state. But the other one is, human rights as embodied in treaties or covenants, such as the International Covenant on Civil and Political Rights. That is a crucial point, because there are some states which do not have constitutions, such as, that do not have written constitutions, such as the UK and New Zealand. And in Australia, even though we have an Australian Commonwealth Constitution, there is no Bill of Rights. So therefore, if a citizen is interested in knowing what is the content of human rights in Australia, you can't find it in the Australian Constitution, and you can't find it in a federal legislation. You must have recourse to treaties and covenants, of which Australia might be a party to, including the International Covenant on Civil and Political Rights. And of course, as we said, other states, such as the US, which have a US Constitution that has a Bill of Rights and is at the same time a party to a lot of these international human rights instruments, then these states don't have much to do any further. But in the case of Australia, these rights, for them to become rights of Australians in Australia, they would have to be incorporated in a particular legislation. And because Australia adheres to the principle of incorporation, what this means is that the mere fact that Australia may sign or may even ratify a treaty does not mean that these treaties operate domestically. So when Australia, for example, becomes a party to the 1966 International Covenant on Civil and Political Rights, yes, the ICCPR becomes a source of binding obligations on Australia, and if Australia breaches its obligations under the International Covenant on Civil and Political Rights, then Australia would be in violation of international law. But there is a distinct question, and that distinct question is, does it mean that individuals now have rights on the basis of the ICCPR in Australia? So in other words, if a citizen feels, and we talked about the need for exhaustion of remedies before the Committee on Human Rights can act on a complaint filed by an individual. So would it mean, therefore, that Australian citizens have certain identifiable rights under the ICCPR which they can enforce in Australia? So let me repeat that. The question is, because Australia is a party to the ICCPR, and because Australia has no Bill of Rights in its constitution, does it mean that the fact that Australia is a party to the ICCPR, Australian citizens can now assert that they have certain rights under the ICCPR, which they can seek then to enforce in Australia? Enforce in Australia, meaning in Australian courts? The answer is no, because it is one thing for a state such as Australia to be bound under international law to obey its obligations under the treaty, but it is altogether different to make an assertion that citizens of a state that are parties to a treaty are then necessarily the subject of certain rights. Because for the rights recognized in the ICCPR to become a source of rights among Australian citizens, these rights must first be incorporated in legislation or in a statute because of the principle of incorporation. So in the absence of a law that embodies these rights under the International Covenant on Civil and Political Rights in Australia, these are not a source of legally enforceable rights. So an Australian citizen cannot say before an Australian court that I have certain rights under the International Covenant on Civil and Political Rights, and I am trying to have them asserted and enforced in Australian domestic courts. That does not exist because the rights under the ICCPR have not been incorporated in domestic legislation. Now, however, even if we say that the International Covenant on Civil and Political Rights does not translate into legally enforceable rights in Australia, it doesn't mean that they have no legal effect. I'm not speaking of political effect, I'm speaking of legal effect. The rights recognized under the ICCPR, in fact, have a legal effect because, for example, in the case of Minister of State for Immigration and Ethnic Affairs versus Steele, case decided by the High Court in 1995, the High Court ruled that the fact that the executive may ratify an international convention would create a legitimate expectation that the executive government and its agencies would act in conformity with that convention. So although it doesn't mean that there are certain rights on the part of individuals that can be legally enforceable in courts, it does lead to legitimate expectations. The net effect of this is that because citizens of Australia, for example, will have a legitimate expectation that Australia, on the basis of being a party to the ICCPR, will obey its obligations under the ICCPR. It would mean that citizens would have a legitimate expectation that when the Australian executive government, meaning maybe the Minister for Immigration, the Ministry of Immigration, or it could be courts looking into the custody disputes, there is a legitimate expectation on the part of citizens that decisions made by the executive and government agencies would be in conformity with the convention. There's that legitimate expectation. What this also means is that when that legitimate expectation is not followed or is breached by the executive, there potentially is a recourse before the courts. Although they are not rights, they do have a legal effect. Now, the other thing we need to point out is that there is a division of powers between the Commonwealth and the states. So if we look at Australian constitutional law, in general, most of the legislative powers on particular subjects belong to the states. And it is only those powers which are recognized under the Australian Commonwealth Constitution to belong to the state, to belong to the Commonwealth, that belong to the Commonwealth. So in general, all powers, all states have the broad powers to legislate on any subject in general, except those that have been exclusively assigned to the Commonwealth under the Constitution, or except those that may violate the Constitution on the basis, for example, of the division of the branches of government, meaning that this especially means that the judiciary is independent from the executive and legislature, or that there might be implied rights that are recognized under the framework of Australia as a democratic country. So states can pass any law that they like, subject only to the powers that belong to the Commonwealth, and subject to limitations under the Australian Constitution. And in relation to this, we go to the case of Toonen versus Australia, where Tasmania had criminal laws that made it criminal for gay men to engage in homosexual sexual relations, such as sodomy. It was a crime. And Toonen filed a complaint against Australia to the Human Rights Commission in 1991. Okay, and he said that that was a violation of Article 17 of the ICCPR pertaining to the rights of privacy. It was also a violation of Article 26 because it discriminated against sexual orientation and identity. And so therefore, gay men in Australia were unequal before the law. And he filed a complaint because Toonen lost his job as general manager of the Tasmanian AIDS Council because the Tasmanian government threatened to withdraw the council's funding unless Toonen was fired from his job, because Toonen was an outspoken proponent of equal rights for gay men, was also openly critical of the Tasmanian laws prohibiting sodomy. So he filed a complaint with the HRC, but the HRC did not act on the complaint until 1994. The HRC only acted on the complaint because it was only in 1994 that Australia became a party to the first optional protocol to the International Covenant on Civil and Political Rights. And on the basis of the complaint filed by Toonen, the HRC ultimately agreed that because of Tasmania's law, Australia was in breach of the obligations under the treaty. So what this actually tells us is that the laws of a constituent state, such as Tasmania, Queensland, New South Wales, or Victoria, have to be consistent with the international law obligations of Australia, which is the state itself, the subject of international law. So Australia, by becoming a party to the International Covenant on Civil and Political Rights, has an obligation to make sure that all its laws, including the laws of its constituent states, are in conformity with its legal obligations. So as a result, the Commonwealth government passed a law overriding Tasmania's criminalization of homosexual law. And because remember that the Commonwealth Parliament has the external affairs power, the power to enter into, the power to pass laws pertaining to the external relations of Australia. And on that basis, it passed a law that overrode Tasmania's criminalization of homosexual sex. So it had an effect because Australia was very aware of the importance of maintaining its reputation as a vanguard of human rights. It had to do something because although the report of the HRC was not legally binding, it had an effect of diminishing the reputation of Australia, and the Australian Commonwealth government therefore passed a law overriding Tasmania's criminalization of homosexual sex. And that does show that although it has no legal effect, it does have an effect in influencing actions of governments. So after studying this topic, you would have been able to discuss and explain international human rights and the international human rights regime, the enforcement of international human rights, and international human rights law as it applies to Tasmania. And so I hope that after you went through this podcast, you would have learned more about international human rights law. And thanks for listening to the podcast. Again, this is Dr. Manjo Oyson, your unit coordinator for public, international, and human rights law. Thank you and bye.